Danny was driving down Federal Highway on a Saturday night when an officer pulled him over for a broken taillight. Within 3 minutes, that routine DUI traffic stop in Florida turned into a criminal investigation, and Danny had no idea it was happening. Every question, every instruction, every test was designed to build a case. By the time Danny realized what was going on, it had already handed the officer everything that was needed in order to make an arrest. Most DUI evidence comes from those first few minutes of the stop. There's one trick that catches almost everyone, and these are the tests you probably didn't know that you had the right to refuse. The first thing that an officer does after pulling you over is talk to you, not interrogate you. They come up to your window, they ask you, where are you coming from tonight? Have you had anything to drink? How many drinks did you have? It feels like a casual conversation. It feels like small talk. That's exactly the point. Everything you say is being documented or recorded. When the officer later writes that arrest report for DUI, those casual answers become evidence and admissions of guilt. Subject stated he was coming from the bar. Subject admitted to consuming 2 beers. You thought you were being honest, cooperative, and polite with the officer. The officer thought differently. The officer was building a case against you. Here's what you need to know. In Florida, you are required to provide your license, registration, and proof of insurance. You are not required to answer any questions about where you are coming from, where you were going, or how your day has been. You can politely decline to answer those questions by saying, I would prefer not to answer questions, in a complete sentence. It's not an admission of guilt. It cannot be used against you, and it's not rude. When an officer asks you to step out of the car, the second layer of observations begin. They are now looking at how you get out of that car. How do you open the door? How do you get up? Do you have to use the car frame in order to steady yourself? Do you plant your feet? Do you sway, stagger, stumble, fall, lean against the car? None of this is casual. The officer is conducting what is called a pre-exit observation, and every detail goes into their report. Subject used the vehicle door for balance. Subject appeared unsteady upon exiting the vehicle. Subject had trouble standing. Subject was swaying. These observations become the justification for everything that follows. If you are asked to step out of the car, you do have to comply in the state of Florida. That's called a lawful order. You have to get out of the car when an officer asks you to do so, but you need to know that every movement is being analyzed. Slow, deliberate movements are not suspicious. They are smart. This is the one that catches the most people. The officers ask you to perform field sobriety exercises. They ask you to do the pen test, the horizontal gaze nystagmus, the walk and turn, or the one-leg stand. These are all voluntary exercises in the state of Florida. You are not legally required to do a single one of them. And here's why that matters. These exercises are designed to make sober people fail. Try standing on one leg for 30 seconds on the shoulder of a highway at 3 a.m. with headlights in your face with an officer watching you, getting ready to arrest you. Nerves, uneven ground, medical conditions, fatigue, even the shoes you are wearing can cause someone to fail these tests that have nothing to do with alcohol. In the cases that I have handled personally, the field sobriety exercises and the videos that come from when people do them can be some of the most damaging evidence that happens in a DUI case. And they are also some of the most unreliable. If you know about the breathalyzer law that we covered in the last video, you already understand what is at stake when the officer asks you to perform these exercises. The legal consequences are stacking up with every step you take on that line. Officers are trained to document DUI stops using specific language that supports the arrest. Bloodshot, watery eyes, a strong odor of alcoholic beverage, slurred speech, fumbling with documents. These phrases appear in DUI arrest reports across the state of Florida with remarkable consistency, almost like they were copied and pasted. And they're subjective observations, not scientific measurements. Were your eyes red because you had been drinking? Or were you staring at a screen for 8 hours? Was your speech slurred? Or were you nervous and talking fast? Did you fumble with your registration because you were impaired? Or were you scared, your hands were shaking from being pulled over at midnight and you haven't looked for these documents in years? The problem is that by the time your attorney sees the report, reviews these observations as they're written facts by the police, challenging them requires understanding exactly how officers are trained to document these stops and where the subjective judgment creeps in. If you've been through a DUI stop, you know exactly what I'm talking about. Did the officer use any of these phrases in your paperwork? Tell me about it in the comments. After a DUI arrest, the officer is either going to ask you on the scene or at the breath alcohol testing center whether or not you want to provide a breath sample. They're going to read you something called implied consent, requesting a breath or urine sample. The way this request is delivered is calculated. Officers are trained to present the test in an inevitable as something you're required to do, while technically it's a warning telling you what happens if you refuse. The tone, the pacing, the phrasing, all of it is designed to steer you towards compliance, to sound like you need to take this test, which is very different than you have the option to take this test, and here are the penalties if you don't. Both can technically be accurate descriptions of the situation. The officer knows what refusal penalties are. You may not, especially under the new Florida law that makes refusing a breathalyzer for the first time a separate criminal offense. What most people do not realize is that the entire sequence from the first question at your window to the breath test request at the BAT center is a single coordinated process. Each step feeds into the next. The casual questions give the officer justifications to ask you out of the car. The exit observations give the officer the right to ask you to do field sobriety exercises. The field sobriety exercises result in a DUI arrest. The DUI arrest results in the ability to ask you for a breath sample. Understanding this, that this is one continuous chain and not a series of unrelated events, is the first thing any good DUI defense attorney looks at. Every link in the chain has to be legally sound. The initial stop was not supported by reasonable suspicion. Everything that follows can be inadmissible. The field sobriety exercises were done improperly. The arrest itself can be challenged. These are not technicalities. These are constitutional requirements that must be followed. And when they are violated by the police, that evidence can result in suppression. That single ruling can dismantle an entire case for the prosecution. If you are facing a DUI charge in Florida, the next video covers the 3 defense strategies that can actually work to beat the case. This is where the real fight actually begins. If you need to talk about what happened during your stop, our number is in the description. Have you been through a DUI traffic stop in Florida? Tell me what happened in the comments.